You are listening to Demystifying Organizations. In partnership with McGraw-Hill Education, I'm your host, Jeff Schatten. Before we get started with today's guest, just a note, if you have questions or comments, you can email me at jeffshatten1@gmail.com. You can tweet me at jeffshatten. If you like this podcast, press the subscribe button and make sure to rate it on iTunes so that other people can find it. UCLA law professor Adam Winkler is a specialist in American constitutional law and the Supreme Court. His scholarship has been cited in landmark Supreme Court cases on the First and Second Amendments, and according to a 2016 study, he's one of the top 20 law professors for citations by the courts. His popular writing has appeared in the New York Times, the Wall Street Journal, Washington Post, Atlantic, Slate, Scotusblog, and the Daily Beast. He's a frequent commentator about legal issues and has appeared on Face the Nation, CNN, ABC News, All Things Considered, Morning Edition, and Marketplace. He's the author of We the Corporations, How American Businesses Won Their Civil Rights, which was named a finalist for both the National Book Award and the National Book Critics Circle Award. Adam joins me on the podcast today to discuss his new book, We the Corporation, which is available to purchase anywhere and everywhere. I'd like to welcome to the podcast Adam Winkler. Thanks for joining me.
Thank you so much for having me.
So, your book that came out relatively recently is an incredible, sweeping history of corporate power in America, the relationship between corporations and the Supreme Court, as well as some of the lower tier courts, and also just understanding how corporations and their power have changed over time. It really, the focus of it ultimately concludes in a discussion about the Citizens United ruling. So I thought we'd start with that. Just give an overview of the Citizens United ruling, why that was so important, and kind of how that framed this discussion for the book.
Well, that's right. I mean, Citizens United was a case decided by the Supreme Court in 2010. And in that case, the Supreme Court held that corporations had the same free speech right under the First Amendment as individuals. So they could spend their money on election ads trying to influence elections. And this overturned longstanding, over 100-year principle that corporations could be subject to special restrictions in the political process, and also revealed, I think, for people a problem they hadn't really thought about before, which was what kinds of rights under the Constitution should corporations have? Should corporations have the same free speech right, for instance, as people? And so I wanted to look into the history of that idea. In law school, students learn about civil rights and states' rights and women's rights and immigrants' rights, but not corporate rights. And yet corporations have been seeking constitutional protections for over 200 years. And in some ways, I frame that movement as kind of a corporate rights movement, and one that's been remarkably successful.
So let's step back to the founding of the country, and even before we became the United States. You have a fascinating bit that shows how much of the very founding of the United States were corporate interests coming over to the U.S. Can you explain how early companies impacted our founding fathers and our founding documents?
Well, that's right. I mean, one of the surprising things I found in my research was the deep role of the business corporation in American government and policy, even back to the earliest days of the colonial era. We think of the Pilgrims landing at Plymouth Rock as our sort of founding myth, our founding story. But that wasn't the first permanent colony in the New World from England. That honor belonged to Jamestown, which was down in Virginia more than a decade earlier than the Pilgrims. And it was fundamentally a business corporation run by the Virginia Company of London and a stock company. based in London, that was responsible for running a business. That is to say, going to the New World, setting up a colony, and finding resources and exploiting those resources for economic gain and for profit. And so, very much at the very founding of the nation is the idea of the corporation and the pursuit of profit. And one of the things I find is in the colonial era, the corporation had a sort of hidden influence on American attitudes about government because so many of the colonies were formed as corporations, as business corporations that were there to trade and to engage and exploit the resources. The frames of government that corporations used became the frames of government for people to use for politics. So,
right. So for companies, one of the key things for companies is about shareholder rights. And this is a very old idea that shareholders would have certain core rights to represent their interests. And what you showcase is that bled over into democratic rights.
Yeah, that's right. So there are part of the ideas of how a corporation is to be governed, the internal governance rules of a corporation, carried over into colonial political life. So when the corporations were formed and came to the New World. The Massachusetts Bay Company was the first colony where the charter and the directors all came to the New World and actually lived here and controlled the corporation here. And they had a charter, and that charter was a written document that set out the powers of the different office holders in the corporation and provided some rights to the underlying shareholders. That idea of a written corporate charter with those kinds of limits became the constitutions of places like Massachusetts. And the idea of a written document that identifies the nature of the governmental office and the limits on that governmental office's power comes directly from the corporation. England had nothing like this in Parliament.
And so what I think is so interesting is that we have this myth that our founding fathers sat in a room and just came up with the rights that we find in our founding documents. And you take challenge to that.
Well, that's right. I mean, any historian who looks at the founding era understands that the ideas and attitudes and culture of that era were informed by the historical context in which those ideas were born. And indeed, when we look at, for instance, the Massachusetts Bay Company charter from the early 1600s, what we find is that it looks a lot like the U.S. Constitution. It provides that there's a governor, that there is a vice governor, that there are as a council of people, like a board that will run the government, that will make the decisions, that pass the legislation, which basically in the corporate terms, we call that a bylaw, an internal government rule that is adopted by the shareholders. But that just translates and becomes the rule of government in the colonies. And so when the founders write the Constitution, they're not thinking about business corporations, or they're not copying business corporations consciously. But the forms of government they're using are very much derived from the structure of corporate organizational forms in that era.
Right. So, and one of the things is that it's not that it was that it had to be that corporate governance would work that way. It's just what works. And so it's interesting that it emerges in the United States where all this is coming over from England, where the prevailing order politically was a monarchy. But in terms of how to structure an organization that's going to deliver value for its shareholders, the rights have to be dispersed, and you have to have some kind of voting system, which makes sense that would then be imparted on the political system in the United States.
Well, that's right. It's a system that works, and it works in the founding era. And what we find is that in the founding era, the corporation makes certain reforms that have an impact on democracy. So, for instance, when the Virginia Company is struggling with its investments in Jamestown because they're not getting enough colonists to come there, they devise reforms like giving the colonists there a voice in a public assembly, basically mimicking the shareholder meeting that would ordinarily be held back in London, so that they could discuss their affairs and adopt bylaws to govern their community. And this becomes an incentive for people to come there because they don't have that kind of voice in government, in their self-government in England, where, of course, the aristocracy and the monarchy ruled. So that idea, that first assembly that happens in Jamestown, which is famous for being the first representative assembly in American democracy, is done very specifically as a corporate effort to encourage investors to come, and it mimics that form of the shareholder meeting.
So when the United States becomes an independent country, what is the role of corporations in the early stages, and what are their rights and what are their limitations?
Well, when the founders wrote the Constitution, they didn't ever address the question of whether corporations should be protected by it. And this was in part because the corporation was prevalent in the one sense in the colonial era. There were some big corporations at the time, the East India Company, for example. But there weren't very many ordinary business corporations in the New World. There were only a very, very small handful. So it wasn't like today where the issue of corporations and businesses are so pervasive that they would think about the issue as clearly. So they didn't address this issue of whether corporations should have rights. And
right, because the majority of corporations at that time are effectively ma and pa shops.
Well, I'm not sure about that, actually. I mean, the majority of corporations at that time can be pretty powerful. So at the founding era, there's only maybe, counts vary because corporations generally had to be incorporated in multiple states. So they could have multiple charters, but it's the same corporation. But there's probably between 8 and 12 corporations in the United States in the birth of the time. And no, they're doing big things. They're like, for instance, they're building the canal along the Potomac River so that for trade can be built. They're running toll bridges and they're running, creating turnpikes, or they're insurance companies. So these are often spaces where they're not mom and pop. A mom and pop wouldn't ordinarily incorporate at that time.
Right.
Because there wasn't that kind of commonality of a corporation, that kind of general incorporation where it's super easy to incorporate, and so all businesses basically take that form just as an easy way to limit liability. And not all businesses, but so many do. That really doesn't happen until really the end of the 1800s, beginning of the 20th century.
Can you talk about the case of the Bank of the United States?
Well, this is a remarkable case. We think about the Supreme Court as existing to protect the rights of vulnerable minorities who might be taken advantage of. But the court has often stepped in to protect the biggest and most powerful entities, and the Bank of the United States certainly fit that bill. It was the richest and most powerful business corporation in America back in the very early 1800s. It had branches from Boston to New Orleans, and the heated debate over the controversial bank is famous really for giving rise to the two competing political parties. Anyone who saw Hamilton the musical would remember how the Bank of the United States splits Jefferson and Hamilton. And what happens is that Jeffersonians, they lose that debate. The bank is formed as a private business corporation, even though it's formed by the U.S. government. But Jeffersonians try to kill the bank by any means necessary. And in Georgia, they pass a law that taxes the bank, puts a special tax on the bank. And the corporation, the bank, wants to challenge that tax. They don't want to pay that tax because they think that they're going to be taxed to death. And so the bank goes to federal court to challenge the tax. And the case presented a familiar question. Are corporations people? Or more specifically, are they citizens under a provision of the Constitution, Article 3, that says that citizens have a right to sue in federal court when they sue citizens of other states? The idea was if you force people to go into state court at the time, foreigners would be taken advantage of by local interests. And the Supreme Court said in this case, 1809, Bank of the United States versus DeVoe, that corporations were protected by this provision and that they did have the right to sue in federal court. This was the first Supreme Court case to expand a constitutional protection to business corporations. And it would sort of lay the groundwork for 2 centuries of cases to come.
So what you're saying is that this is a step where corporations are able to take on the idea of personhood.
That's right. Corporations are able to claim the rights of individuals under the Constitution. And when we think about this case, there's a couple of remarkable things about it. Not only is that the corporations are effectively given the same rights as citizens under Article 3 of the Constitution, but that they're doing it in 1809. the first Supreme Court case on the rights of African Americans wouldn't be decided until 1857. That case was the infamous Dred Scott case. What the court in the Dred Scott case said was that African Americans could not be citizens under this exact same provision of the Constitution. So this kind of highlights, I think, a trend that we see in American history, which is that the Supreme Court's generally not used its power to protect the dispossessed and minorities, but often read the Constitution quite broadly to protect business interests and corporations.
Right. So, and we usually think of the 14th Amendment as being the amendment that freed the slaves. And you point out that while there have been many cases have appeared before the Supreme Court that address the rights of African Americans, it's more often been used to address the rights of corporations.
That's right. There was a study done in the about 1913, and it looked at all the 14th Amendment cases that had been heard by the Supreme Court between 1868, when the amendment had been adopted after the Civil War to guarantee the rights of the newly freed slaves, and 1912, when he was doing this study. And what he found was pretty remarkable, that the Supreme Court had heard only 28 cases on the rights of African Americans. And in most of those cases, they ruled against African Americans, allowing, in cases like Plessy against Ferguson, Jim Crow laws to sweep across the South. And during that same period of time, however, the Supreme Court had ruled in over 300 cases on the 14th Amendment rights of business corporations. In many of those cases, ruling in favor of the corporation and using the Constitution to strike down laws that discriminated against corporations in some way, shape, or form.
Can you give some examples of how the 14th Amendment was used to expand corporate rights?
Well, the best example comes out of the sort of one of the key foundational cases, a case involving the Southern Pacific Railroad Company. California adopted a constitution in 1879 that imposed a special tax on the property of railroad companies. And the Southern Pacific Railroad didn't want to pay that tax, so they went to court and they said, this law violates our 14th Amendment rights. And at this time, the Supreme Court had never said that the 14th Amendment applies to corporations. But the Southern Pacific Railroad hired a very illustrious lawyer by the name of Roscoe Conkling, who himself had been a leader of Congress, had been nominated and confirmed to the Supreme Court once, turning the seat down, and more importantly, had been one of the drafters of the 14th Amendment when he was a young congressman. And Conkling went before the Supreme Court and said that the 14th Amendment was written not just to protect the rights of the newly freed slaves, but also to protect the rights of business corporations.
Right. So some of this hinges on the language that he uses.
Well, that's right. The 14th Amendment says that no state shall deny to any persons the equal protection of the law. And Conkling argued that as originally framed, the 14th Amendment had only guaranteed rights to citizens, and that the language had been changed to persons so that there would be no confusion that corporations were included too, because for many legal purposes, corporations are deemed to be people. That's actually a very well-established business law principle. The idea of corporate personhood, you go back to 1757 in Blackstone's commentaries on the laws of England, and he describes a corporation as an artificial person. That is to say, it has its own standing in the eyes of the law.
And so what's the aftermath of Conkling's intervention?
Well, although Conkling misleads the Supreme Court, the court ultimately agrees that corporations should have the rights under the 14th Amendment, and they use those 14th Amendment rights to strike down laws that, for instance, require businesses to pay minimum wage or has set maximum number of hours that you can force someone to work. The Supreme Court during this period became famous for striking down laws regulating business. It's a period in the Supreme Court's history known as the Lochner era, roughly 1890 to 1936. And during that period, the court very vigorously very broadly read the Constitution to strike down many forms of business regulation, from zoning laws to, like I say, minimum wage laws, collective bargaining laws, and things like that.
So we think of things like search and seizure, right? So for an individual, you have to have a warrant if you want to go search their premises. How do ideas like that change or maybe ebb and flow for corporations?
Well, that's one of the big questions for corporations and the law has always been, can a corporation be guilty of a crime? Usually a crime takes not only an evil act, but an evil mind too. The idea that you were trying to do something harmful to someone, and so it's hard to understand how a corporation would have that kind of intentionality. At least that's how people thought about the issue for many, many years, for many decades. And this changes around the turn of the 20th century. At the beginning of the 20th century, when there's these big trusts that are really controlling all these industries, lawmakers look to criminal law as one potential way to try to sort of cabin corporations from doing the wrong things. And so people start to think about this a little bit differently. And as one court says, if a corporation can build mountains and dig valleys, certainly they could do so with a bad intent as well as a good intent. But the imposition of criminal liability on corporations leads to a whole series of questions for the Supreme Court. Many of the rights in the Constitution are rights that are designed for criminal defendants, from Fourth Amendment rights against unreasonable searches and seizures to right to a jury trial, to a right to an attorney, right to due process of law, and protections against cruel and unusual punishments. And the question that the Supreme Court has to face is, do corporations have those criminal rights too? And ultimately, the court will say, for the most part, yes.
And then let's move to the 20th century. So what are some of the main events in terms of the corporate desire for deregulation and for independence? How did that change in the early 20th century?
Well, we do see that corporations are seeking sort of independence and autonomy. And we should understand that's why corporations use the Constitution. Why would corporations seek constitutional rights? Basically for the same reason people do, because they want to create a space of liberty and autonomy where the government cannot tell you what to do or how to act. And so that's sort of the motive of corporations. But over the course of the 20th century, well, one thing I should say about at the very beginning of the 20th century is that the Supreme Court, although it's in a very business-friendly period, the court does draw some boundaries and lines and says there's some places where corporations do not have rights. And the court says that corporations should have rights of property under the Constitution. That is, they should have rights to protect their property from being taken by the government without paying just compensation. It would be absurd if the government could come in and seize Google's campus up in Northern California and not pay a dime of compensation. Mm-hmm. But if the corporation had no constitutional rights, then maybe government could do that. So what the Supreme Court back then said was that corporations had property rights, but they didn't have rights that are associated with personal liberty. Things like rights of conscience, rights of political participation, or rights of bodily integrity, and that those kinds of rights were restricted to natural people. And so the court said corporations don't, for instance, have rights to participate in electoral politics or spend their money on election ads. A ruling that 100 years later would be basically overturned by Citizens United.
So is that the origins of the restrictions of corporations on political movements?
That's right. The very first campaign finance laws really were that were widespread were bans on corporate contributions to candidates, and they were adopted right at the first decade of the 20th century, in part in response to a major scandal involving Teddy Roosevelt. We think of Teddy Roosevelt as the famous trust buster who went to break up the trusts, and indeed he did try to break up many trusts, but he was also the presidential candidate who received more corporate financing than probably any other candidate in American history. More than 70% of his election funds in 1904 came from business corporations. And that was all hidden at the time. They didn't let anyone know that. And a year later, after he won re-election, it became known that he had been financed by these big corporations. And it challenged his image as a trust buster and the public's trust in him, and actually led to a wave of laws that restricted corporate spending on elections.
Can you walk through how corporations used the civil rights movement as the laws that were enacted during that period, and as well as some of their methods in order for their ends?
Well, right. This is one of the interesting parts of the story is that in the early 20th century, when the Supreme Court is very business friendly and rules in favor of corporate rights a lot, it also draws some boundaries and limits to corporate rights. And over the course of the 20th century, as the Supreme Court becomes a little bit more progressive, surprisingly, we find the progressive courts of the New Deal and then the Warren Court, going up into the late 1960s, really start to expand the rights of business corporations and corporations more generally. In response to concerns about civil rights, about concerns about censorship. A notable case happens actually before the civil rights era, which is when Huey Long, the governor of Louisiana, who was a little bit like Trump before Trump, a very sort of boisterous populist who ran on the eve of the Great Depression, promising to make Louisiana great again.
Mm-hmm.
When the media of Louisiana came out against Long's program, he declared war on them and had his allies pass a tax on the advertising revenue of the big high circulation newspapers in Louisiana. And the newspapers fought back by going to court and saying, hey, this is a violation of our freedom of the press. And one of the essential questions that the Supreme Court has to face, is do business corporations like these newspaper companies, do they have First Amendment rights? Because we've long said, the court says, that corporations don't have liberty rights. They don't have those rights to be involved in political speech and to engage in politics. And yet here are these newspapers that are really important voices in American public life and play an important role in checking the government and encouraging democratic dialogue. And they're organized as corporations. Should they have freedom of the press? And the Supreme Court ultimately says yes. And it's a real important landmark decision that establishes that business corporations, at least in some circumstances, have First Amendment rights, long before Citizens United.
Right. So on the one hand, businesses have some First Amendment rights, but on the other hand, they're restricted in terms of the political sphere for campaign finance, for campaign ads. So how does that move forward, and how is that tension resolved?
Well, I think it ultimately gets resolved in Citizens United, but the story of how it gets there is pretty remarkable too, and involves a case in the 1970s in which the majority opinion was written by Lewis Powell. And this case in the 1970s, known as the Bilotti case, was a case that many, many years before Citizens United, did suggest that corporations had some political speech rights and had a right to spend their money, at least in some election campaigns, is specifically dealing with referendum issues and initiatives. And what's interesting was that decision was written by Lewis Powell, who just before joining the court had written a memorandum to the Chamber of Commerce called The Attack on the Free Enterprise System. When he wrote the memo, it was the era of Nader and consumer rights, and we're seeing the first environmental laws passed by Congress. And Powell writes this memo to the Chamber of Commerce that outlines a strategy for how business interests and those who support the free market can fight back against Ralph Nader. And historians today look at the Powell Memorandum as a really influential document in the rise of the new right and the sort of free enterprise, free market political view in America as that sort of takes hold really in the 1980s. But Powell gets a lot of credit for it. And that memorandum, he basically transforms it into constitutional law in a case, in this Bilotti case, saying that corporations do have a right to spend their money on initiatives and referenda if they wish to.
But that's only on policy related. Am I correct? Is this the bit that's they can comment on policy, but not on a specific race or specific politician?
Yeah, at the time, the only issue before the court was whether a Massachusetts law, which prohibited corporations from spending their money on ballot measures, so specifically ballot measures, not candidate elections, but ballot measure campaigns, whether that law was unconstitutional. And the Supreme Court held it was unconstitutional. And it said, we're not saying anything about candidate elections. That might be a separate problem. We'll leave that to another day. But the court in this Bilotti case sort of lays the groundwork for Citizens United and makes an important point, too, where the court says in the Bilotti case, Powell says, it doesn't matter that the speaker here is a corporation, that the identity of the speaker is totally irrelevant. All that matters is that the speech involved is worthy of protection. And that's the same logic that Citizens United will use in 2010. Not that corporations have some value to add to the debate necessarily, but that you cannot restrict political speech, because that's the kind of speech that the First Amendment protects, regardless of the identity of the speaker.
Right. So the Citizen United one, which is what I'm most familiar with, surrounds it's kind of a quirky case, because you have this video that's come out about, or this documentary that's come out about Hillary Clinton, that is clearly a partisan piece, that kind of throws this all into a tailspin. What becomes the central question that they're addressing?
Well, the case presents what could have been a very small issue, which was whether this particular movie that was basically a documentary about Hillary Clinton, a political hit job, you might say, that kind of documentary, but it was a documentary, and there's a question about whether that should be thought of as a corporate, and it had some corporate money that had financed it. Was that a corporate financed election ad? We know that under the law, the corporations couldn't take out an ad on TV saying vote for or against Hillary Clinton.
Right. So if this had been just a political action committee that had done this, there'd be no question.
No question. There's no doubt that the Hillary documentary could have been produced and distributed without any limitation. What was the limitation was if it was deemed an election communication designed to influence the election, and it was financed by a corporation, then it would run afoul of the principles that go all the way back to Teddy Roosevelt's scandal, that corporations can't spend their money to influence elections, and candidate elections at least. And what the Supreme Court ultimately says is that, and so it's originally the debate is about whether this particular movie fits under the definition of an election communication. But what happens is once the justices go behind closed doors after the case is argued, the 5 conservative justices on the court decide, we want to make this case about something bigger. We think that you should never restrict any kind of corporate financing of election communications. The question is not whether this particular movie fits in the definition of an election ad. It's that you can't stop corporations from financing election ads at all. And so that's ultimately what Citizens United says, that corporations have the same free speech right as individuals and can spend their money on election ads, even in candidate elections.
Right, and it's unleashed a torrent of spending, like $1 billion, I think, in the following election cycle. Is that something that where do you see that going?
Well, I think we're going to see more and more of that. I mean, the financing, Citizens United has definitely helped open the floodgates, and some decisions that have come after Citizens United have opened the floodgates even more. One of the surprising things is that in some ways corporations haven't been as active in spending money on election campaigns as we might have expected. But I have a feeling that's a matter of time.
Which would be right. So the argument for that would be we have a $20 trillion economy, and it's still $1 billion here and there being spent on elections.
Yeah, no, that's right. And corporations can afford to get involved and spend a little bit of money, and we're seeing increasing willingness of corporations to get involved in politics. There's no doubt about that. But nonetheless, I think that the thing about Citizens United is that it's not just led to more money coming into election campaigns. It's definitely done that. But by expanding the rights of corporations, it's also had a sort of a cascading effect, and that we're seeing corporations claim other rights too that we would have thought corporations might not ordinarily be able to claim. So, for instance, the Supreme Court, since Citizens United, has ruled in the Hobby Lobby case that corporations have religious liberty rights under a federal statute, and allowed the chain of craft stores to exempt itself on the basis of the owner's religious beliefs from an Obamacare rule that required large employers to cover employee birth control in their health plans. And we've seen just this past term in a case called Masterpiece Cake Shop, where the court held that a business corporation had First Amendment religious freedom and upheld the claim of a wedding cake baker, who didn't want to bake a cake for a same-sex couple. couple, the court said effectively that corporation, Masterpiece Cake Shop, had its First Amendment rights limited.
I know you might not be in the business of prognosticating, but now that it's a pretty solid 5-4 conservative majority, where do you see things heading?
Well, I do think the corporate rights movement in some ways is gaining steam. Corporations have been especially aggressive in the area of free speech. In addition to Citizens United, which struck down campaign finance limits, corporations have challenged a number of laws protecting consumers and investors using free speech and First Amendment principles, including successfully striking down mandatory labels for growth hormones and dairy products, striking down graphic warnings on cigarette labels, and striking down a securities law that required public companies to disclose the use of conflict minerals. And so we are seeing corporations really aggressively use the First Amendment. In particular, there was a recent study that found that 50% of all First Amendment cases that are brought in federal court are brought by business corporations or trade associations that represent businesses. So in many ways, we're seeing the corporations really aggressively use these rights. I already mentioned the religious liberty rights that are really central to some of the debates over access to the public square by LGBTQ people.
And if you were to have all 9 votes yourself, where would you draw the balance between corporate rights and the limitations on corporations?
It's such a great question because it's not necessarily easy to answer with an all-in or all-out approach. And I think one of the things I definitely learned in my research about the rights of corporations is that we may need a more nuanced answer. So there is, for instance, a big movement to amend the Constitution now, pass a 28th Amendment that would declare that corporations have no rights whatsoever. 19 states have endorsed some kind of resolution that moves in this direction. I think that would be a mistake because we've seen that corporations need, for instance, the right of freedom of the press to protect themselves against censorship. The 20th century has seen plenty of examples of efforts to censor newspaper companies, and we need them. We need those newspaper companies, and so they must have some rights. That if corporations don't have any rights, then, as I said, Google's campus could be seized without any just compensation. And that seems fundamentally wrong. At the same time, I think corporations should not have all the same rights as individuals, and that maybe the courts back in the early 20th century were onto something when they said corporations as a general matter have property rights, not liberty rights. And while I don't think that distinction is going to hold in every case, I think that's a good starting point for analysis, where you presume corporations do have property rights, but they have to make a very strong showing that they would need liberty rights for that to be for those to be extended.
All right. Well, it's been amazing. Thank you so much for joining me on the podcast.
This has been a real pleasure.
Thanks for listening to the podcast today. If you have any questions or comments, you can email me at jeffshatten1@gmail.com. You can tweet me at jeffshatten. If you like this podcast, press the subscribe button and make sure to rate it on iTunes so that other people can find it.